Okay, we're going to get started.
All right.
Good afternoon. Magandang tanghali sa inyong lahat. My name is Mari Pandoma Colado. My pronouns are she and her. I'm a trial attorney at the Dolan Law Firm and the president of the Filipino Bar Association of Northern California. It is my pleasure to introduce this webinar today on navigating tenants' rights during COVID-19. This webinar is a part of a series of FBANC programming in response to the COVID-19 pandemic. Please go to fbank.org/COVID-19 for more information and additional resources. Maraming salamat to Asian Law Alliance, API Legal Outreach, and the Law Office of Andrew Vento Gabriel for collaborating with us on this webinar. Thank you for everything that you do for the Asian Pacific Islander community. And I would also like to thank Assembly Member Rob Bonta and David Chu for joining us this afternoon. Before I introduce our moderator today, I want to let our viewers know that information provided in this presentation does not and is not intended to constitute legal advice. Instead, all information, content, and materials available during this presentation are for general informational purposes only. Attendees of this presentation should contact their attorney to obtain advice with respect to any particular legal matter. We have such a great lineup of speakers today, and I am thrilled to introduce our moderator, Joey Badua. Joey is a staff attorney focused on housing rights and eviction defense at API Legal Outreach. Joey graduated from Golden Gate University Law School and is a past recipient of the FBANC Foundation's Raymond L. Ocampo Jr.'s Family Scholarship. Go ahead, Joey.
Thank you, Mari, for that great introduction. Our first speaker is the first Filipino American ever elected to the California Legislature. He has been representing California Assembly District 18 since 2012. He grew up in a trailer down the street from Cesar Chavez. He was raised by parents who fought alongside Martin Luther King Jr. His mother is still active in the Filipino social justice movement. He is a graduate of Yale College and is undefeated in jury trials as an attorney. He is a staunch advocate for safety net legislation, much like the legislation we are discussing here today. He has worked alongside tenants rights advocates to craft legislation to protect those who are affected by COVID-19. A personal memory of mine with the next speaker is as a law student and attending events hosted by Filipino Bar Association of Northern California. FBANC prides itself for engaging with law students to meet attorneys, judges, legislators to kind of see how the practice of law is. And one law school event, I had the chance to meet Assemblyman Rob Bonta, who spoke about his mother. And I also have fond memories of him talking about how difficult it was as a person of color to become an attorney, to always speak up for those who are left on the sidelines. He is someone who fights for necessary legislation while still understanding that there is always more work to be done. And because of his advocacy, I am honored to introduce Assemblyman Rob Bonta.
All right, I'm going to do my introduction again. I spoke on mute, which is my signature move on these calls. Hi, everybody. Rob Bonta here in the California State Assembly. Thank you very much for that kind introduction. Appreciate the opportunity to spend time with you. today and talk a little bit about tenants' rights and AB 3088. And the first thing I'll say, and I know my colleague, Assemblymember David Chu, with whom I've worked on many tenants' rights, tenant protections efforts with, will be sharing some of his views as well. But AB 3088 was an important and necessary protection, but in my view, not enough. And we can continue to build on it and work towards doing more and providing additional protections. But for now, the only choices we had were AB 3088 or nothing. And if we did nothing, then on September 1st, earlier this month, evictions would have proceeded, the Judicial Council's protections would have expired, and we would have seen people in the middle of a public health pandemic and COVID-19 pandemic evicted potentially into homelessness, onto the streets, into settings that, of course, are devastating in non-pandemic times, but certainly during a pandemic, have an additional risk of for public health, for health, and for life. So this was an important win, and one of the reasons that it was challenging is because it was a urgency bill, meaning that it took effect immediately upon signing. And when that happens, when there is an urgency bill, that triggers a 2/3 requirement. So we needed to marshal 2/3 votes in both houses and earn the governor's signature. And that meant that the stakeholders had a little bit more veto power during the negotiations, more than normally we would have liked. And that the protections for tenants were not as strong as we would have provided for should we have had the ability to define what that is on our own. And we had an earlier bill that Assemblymember David Chu was the lead author on that outlined the protections that we were hoping for. But in anything in the legislature, it's the art of the possible. Compromising on the bill is often something that we need to do, even though we don't compromise on our values. And so we wanted to deliver something real and concrete, provide relief, support, protection for tenants now, and meaning as of September 1st, when they were at risk. So AB 38 prevents unnecessary evictions in the wake of COVID-19 by giving landlords and tenants a path to address unpaid rent while keeping tenants housed. So one important thing to note about how AB 3088 works is that there is no cancellation of rent. There is no dismissal or erasure of the rent. The rent is still due after the pandemic in 2021 and can be sought in small claims court by landlords, but it does provide protection while rent is being unpaid, so that no one can be evicted between the start of the pandemic and September 1st for failure to pay rent. And then going forward on September 1st through early 2021, as long as individuals pay 25% of their rent, 1/4, a fraction of the total rent due, they can be protected from evictions. And so that was kind of the grand compromise. We also have always heard concerns from our small mom and pop homeowners who rent, our small mom and pop landlords, wanted to make sure that they were getting protection as well. Many of them rely on, many of them are Asian American, many of them are immigrants who have invested in property as part of their retirement security, part of their future, and they rely on rent to be able to pay their mortgage. So we are, of course, are aware of and cognizant of and focused on that connection, and wanted to make sure that our small mom and pop landlords were not hurt or harmed as well. And 3088 provides protections to them in the form of the Homeowners Bill of Rights protections, making sure that certain protocols and practices are followed should there be a foreclosure procedure because of a failure to pay their mortgage. They get a single point of contact. There is confirmations in terms of the receipt of information back and forth. If a modification is moving forward, there's no dual tracking, so that you can be working on a modification of a mortgage at the same time you're working on a foreclosure, and a foreclosure is moving forward. So protections for both our tenants protections for our small mom and pop landlords as well. And, we have 17 million Californians that rent the place they call home. They have often been in this housing affordability crisis in California, felt at risk and vulnerable and exposed. And that was before COVID, even more now. So we wanted to deliver something that was real, that kept them in their homes, kept them safe, allowed them to shelter in place so that they continue to have shelter to do that, allowed them to follow stay-at-home orders and so that they had a home in order to do that. And we're going to continue to build on this progress and help provide additional support as we return to session in January. And I know Assemblymember Chu is very focused on that. One important part of the puzzle is federal money, and a federal stimulus package can really make a difference if small mom and pop landlords could be paid rent by the government or partial payments to the government. That would relieve the tenants. It would allow the small landlords to be able to pay their mortgages. The lack of the ability right now of California to provide that funding has been a challenge, and really it should be something that comes from the special capital infusion powers of the federal government, their ability to provide stimulus packages, to send money to the states and to local jurisdictions, to tenants and to small landlords. So that's a really important piece of the puzzle going forward that we hope will help. And I think that's a good overview of where we are. It's sort of one of those things where because of when you look at the policy and the politics, the voting threshold of 2/3, the need to bring on board a number of folks who have not been supportive of tenants in the past. And, we got AB 1482 passed 2 years ago, the strongest tenant protection law in the nation, the strongest in the history of California. It was a combination of two bills that Assemblymember David Chu and I worked on, an anti-rent gouging bill that he was lead author on, a just cause protection bill that I and Assemblymember Grayson were lead authors on, and we all worked together to get that passed. That required 50% plus one, which is why we were able to get that done. With 2/3, similar levels of protection were much more challenging. But 3888 is a strong protection for now. It keeps people in their homes. It provides a pathway for folks to avoid eviction for failure to pay rent until early next year in 2021. So let me leave it at that for remarks. If there's any questions, either in the chat or live, I'm happy to answer them.
Thank you so much, Rob Bonta, for being with us today and for passing and really helping tenants out with this. Go ahead, Joey. Are there any questions from the attendees?
Thank you. As a tenant, how would you what recommendations would you have to voice out and advocate for stronger tenant protection?
Yeah, thank you for that. I mean, a number of ways, and there's a growing volume for tenant voices in the state capitol. The coalition is growing and building. There, when I was there just 2 years ago, the voice of tenants was not nearly as strong as I hoped it would be. All the bills on a policy perspective, when there was tension between landlords, apartment owners on the one hand and tenants on the other, would be decided on the side of the apartment owners and the landlords and not the tenants. And only with folks like Assemblymember David Chu, who's fought so hard for tenants, my push, a number of other colleagues, including Assemblymember Tim Grayson, who really just felt compelled because he talked to some impacted people in his district about their precarious positions and their vulnerability as tenants. The voice has gotten stronger, but working through some of the groups, like ACE, like Tenants Together, like Western Center on Law and Poverty, that many of those folks have built the coalition to raise the voice of tenants. So we're really interested in what tenants have to say about what the next version of a law that would provide protection after February 2021 and March 2021 would look like. And so, sharing your ideas, working through those coalitions that have existed to uplift the voices of tenants is really important. But those are some of the leading voices, and certainly Assemblymember Chu, as the Housing Committee Chair, is very open to ideas for consideration to protect our tenants who need it.
Thank you so much, Assemblymember Rob Bonta, for all your hard work.
Thank you.
Okay, so now I will be explaining a summary of today's presentation. The speakers that we have today who work day to day, hear the experiences of tenants, will be answering these questions. What are the protections available for tenants who cannot pay rent due to COVID-19 under the Tenant Relief Act? What are the nuances between federal, state, and local protections? How can tenants avail protections? What are the eligibility requirements for them to avail protections against evictions because of their inability to pay rent? What can tenants expect from landlords, and what are landlords supposed to do? What are their responsibilities regarding tenants who are unable to pay rent due to COVID? We will go over hypothetical and practical tips, and then open the floor up for Q&A. The next speaker, oh, I'm sorry. Could you please go to the next slide, Mari? Thank you. Before I go to the speaker, just a little, oh, thank you. Just wanted to show this resource available if you're interested in reading the AB 3088 bill, also known as the Tenant, Homeowner, and Small Landlord Relief Act. There's also the CDC order in play, and our speakers practice in these cities: San Francisco, Contra Costa, Solano, Alameda, Santa Clara, San Jose, and Mountain View. And I believe we'll be providing the slideshow after this presentation is done. Next slide, please. And now I'm proud to introduce a staff attorney from the Asian Law Alliance. He is an experienced housing attorney who has represented clients and tenants in fair housing issues, as well as unlawful detainers. He has dedicated his career advising clients of their rights, negotiating settlements, and filing briefs, arguments in court on behalf of his clients. I am pleased to introduce Kenneth Tejada.
Thank you for the introduction, Joey. So I'm going to briefly go over AB 3088, the COVID-19 Tenant Relief Act of 2020. The AB 3088 was signed into law on August 31st. It takes over for Newsom's executive order and the Judicial Council's orders restricting UDs. So first thing you need to know is that as a general matter, if you've lost income because of COVID-19, then you can't be evicted for not paying your rent before February 1st, 2021. However, to get those protections, you will need to demonstrate to your landlord that you've lost income. For anything between March and August, you just need to show that you've lost income. Under AB 3088, You just need to sign a declaration saying that you've lost income. However, if you are a high income earner, a landlord can request a say documentation showing a financial hardship. But it's a general matter, if you're not making a six-figure salary, if you're not making more than 100,000, you shouldn't have, saying the landlord can't ask you for this. Now things get a little bit more complicated if you can't afford to pay rent after August, specifically between August and January, in which case you'll have to pay a portion of the rent owed for those months. Approximately it's 25%, so that's a little bit over, over 1 month's rent that needs to be paid by January 31st. It also prohibits anything from certain UDs from before October 5th, 2020, to try to block off any attempts to evict someone because they didn't pay rent for, because they had a COVID-related loss and didn't pay rent before that time period. It also adds another layer of protection. The tenant protections in place from AB 1482, which prevent an eviction, which require that there's a just cause before an eviction, have now been extended to all tenants. Originally, there were restrictions on who it applied to. Until February, those protections now apply. But there are a few restrictions. If a landlord is trying to evict based on making repairs, those repairs have to be to ensure the safety of the unit. And the landlord, the required notices require more time. Usually it's 3 days. It's now been extended to a 15-day notice, and that's 15 business days. So weekends, holidays don't count. And any rent from that is owed, landlord can't collect on that until March. These protections apply to all tenants. So this includes mobile home tenants, and it is not dependent on citizenship or being a lawful permanent resident. It's tenant regardless of any citizenship status. Is there anything else?
Thank you, Kenneth. So this is an overview of the Assembly Bill 3088. Again, this protection was meant to stop the wave of evictions that would happen due to the businesses, closing down to protect the spread of COVID-19. And we will be getting Assemblyman David Hsu also to speak more about this. I also wanted to note that the protections apply to all residential tenants, including mobile home tenants. And there are protections for tenants with various immigration status, free from retaliation. And Kenneth, I wanted to discuss with you a little bit more about this, this law.
Okay.
And would eviction be a possibility for a renter who has not lost income because of COVID?
It would be possible, but because the AB 1436 protections have been applied to everyone, it would still need to comply with the AB 1436 just cause requirements.
And you explained very well the 15-day business day notice that would need to be responded to by a tenant. Does Asian Law Alliance have attorneys that will be able to help review those notices?
Yes, if you're in Santa Clara County, feel free to contact my organization. We will take a look at, if you get any kind of notice of termination, we'll take a look at it. We can advise you on it. We can't promise everything, but I can at least promise that I can take a look at it and figure out if it's legitimate or if there's anything that we can help with.
Yes, we urge tenants to seek help. The earlier, the better. If you want to contact our respective offices to understand your particular situation, this is our phone number and our language access capabilities. We also urge that tenants document, collect the notices of reduction of hours, for example, receipts for expenses related to COVID-19, personal PPEs. If you're having to care for a family member due to COVID-19 and that caused you to work less hours. Do you have any other thoughts about that, Kenneth?
So COVID-19 related loss of income can be loss of a job. It can be your job, you're only working part-time or being furloughed. It can even be you've lost hours because you've had to remain at home to take care of your children or take care of someone who's had take care of a family member who has COVID-19, or even because you've needed to take time off because of a COVID-19 related illness. These are just examples, and these aren't exhaustive, but those are the most common examples.
I see that we have a question. Are the rent increases allowed at this time or not?
So AB 3088 doesn't really have anything on rent increases, but there are a few local ordinances that have barred rent increases. If you're for example, if you're in a rent control department in San Jose, rent increases are barred. But as it stands, at least just from my overview of AB 3088, there doesn't seem to be anything dealing with rent increases.
And similarly in San Francisco, the San Francisco Rent Board Stabilization Act has percentages of allowable increases and the required notices, procedures that the landlord would have to follow in order to properly increase someone's rent. Again, we recommend you speak with an attorney regarding your particular case. It's best to have the notices of the request to increase available for review by the attorneys. And that way, either our office or another office, the San Francisco Bar Association also has lawyer referral phone hotlines that will be able to look at your specific case. And it is my, I'm sorry. Let's see. Also, it is also my understanding that Assemblyman David Chu will be arriving shortly. In the meantime, I am going to ask you, Kenneth, besides housing work, what other types of law does Asian Law Alliance practice in?
So Asian Law Alliance does work in immigration, domestic violence, public benefits, and housing. We also do We also run the Federal Per Se program, and we also do some degrees of community outreach. But if you're in Santa Clara County and you need help with immigration, domestic violence, public benefits, or housing, give us a call. We'll see if we can help.
And API Legal Outreach, which has 2 offices in San Francisco and Oakland, also practices in immigration, domestic violence, elder abuse. We also have a youth council with applications that begin in June, July in the summertime. And there's our phone numbers. Does anyone else have questions or follow-up questions? Please feel free to use the Q&A feature in Zoom. Thank you. Our next speaker is the son of immigrant parents and a graduate of Harvard University. He represents District 17 in the California Assembly. Before running for office, he was a criminal prosecutor at the San Francisco District Attorney's Office, a civil rights attorney with the Lawyers Committee of Civil Rights, and president of the Asian American Bar Association of the Greater Bay Area. Throughout his career, he has authored 59 laws addressing wide spectrum of issues, including housing, houselessness, education, environment, health, and civil rights. When COVID-19 hit the Bay Area, he felt the need to author this bill. He was quoted saying, "This will not be the ultimate solution to addressing COVID-19 evictions, but will tide us for the next 5 months." As an assembly member who fights for the rights and dignity of tenants, it is my honor to introduce David Hsu. Oh, there has been a technical difficulty. I apologize for the delay. We are working on it. And while we wait, just wanted to let the attendees know about the Filipino Bar Association of Northern California. We have webinars to help folks navigate through these tumultuous times, virtual clinics, other programming. If you're interested, please contact Marie Bandamo Collado. And Assemblyman David Hsu is on.
Hey everyone, how are we doing?
Hello.
So catch me up. I know. Did my colleague and close friend Rob Bonta already hop on?
That is correct. He mentioned that while AB 3088 will be like an emergency patch to get us through the next coming months, there will be legislation that hopefully provides further help, as well as invoking the federal government to provide stimulus to support tenants and homeowners.
Right on. Well, thanks for having me on, and apologize that I'm zooming in and zooming out in a couple of minutes. Today is actually the last day for Governor Newsom to sign a whole slew of bills. So there's been a lot of engagement with the governor's office. But you know, what I'll do is maybe just talk a little bit as the author of the bill on why we did it, what it is, and sort of next steps. My guess is you guys have already covered in the last half hour a lot of this, but it goes without saying that there are millions of Californians at this moment who are hanging by a thread, for whom one rent check, one paycheck means a difference between homelessness and being housed, between eviction and an unlawful detainer, or being able to continue living under the roof that you've lived in for decades. And this really came to a head because the Judicial Council lifted its temporary eviction moratorium on September the 2nd. I actually want to take a moment and thank the Judicial Council for extending it as long as they did for 6 months. And of course, we all know that the Supreme Court is headed up by one of our most prominent Phil-Am attorneys, the Supreme Court Justice Chief. And we're just grateful to her and her leadership. They were under a lot of pressure, in part because there were a lot of lawsuits about their authority to continue to put an eviction moratorium in place. And they effectively said to the legislature and Governor Newsom, you guys have to put some laws in place because we are exerting our emergency powers, but long-term, this has to be dealt with through state law. So we were under the gun to get something done. As the chair of the Assembly Housing Committee, it really fell on me, and as someone who's led on a lot of tenant efforts, to be the face of the pro-tenant perspective in the negotiations over this. It was round-the-clock negotiations for many, many weeks, and pretty intense. And frankly, the most difficult legislative negotiation I've been in my 12 years now in public office. So, my guess is you've summarized some of the guts of what this bill are about, but effectively what we were able to do was to provide protections for tenants who are experiencing COVID-19 economic impacts from being evicted due to non-payment of rent, at least until the end of January. So I qualify that because what we weren't able to do was help folks who are facing eviction who are not able to demonstrate a COVID-19 economic impact. And it also does not protect tenants who are facing evictions for all sorts of reasons beyond the non-payment of rent. Nor does our law cancel rent, which is something I know a lot of folks have been wanting. It converts the rental debt into a consumer debt collectible in small claims court. It still says that tenants all owe all missing rent, but they can't be evicted if they follow the rules that I assume you guys have gone into, and effectively are paying about a quarter of their rent between now and the end of February. That being said, it was estimated there were over 5 million Californians who, because they weren't able to pay some rent over the past 6 months, or likely are not able to pay some of the rent over the next 5 months, it will give them protections and make sure that we're not going to see what we had all been horribly concerned about, this massive tsunami of evictions that otherwise could have been kicked off September 2nd if we were not able to pass this law. So this law, I say a lot of things about AB 3088, including the fact that it's not perfect. It certainly does not address all the needs that we have. Part of our challenge was in the legislative process to pass anything to go into effect immediately. You need a 2/3 vote. So typically a lot of bills, for example, some of my bills that have gotten signed by the governor in the last couple of days are going to go into effect January the 1st, and thus only required a 50% threshold in the legislature. Getting a 2/3 vote is really, really difficult. And because of that, we weren't able to negotiate all the things that we want. Also, for obvious reasons, this bill is going to end in 5 months. This was as much as we were able to negotiate vis-a-vis the landlord industry, but also that date of January 31st is significant for two reasons. One, our legislative session starts again in early December. We come back full time in January. We have time if we need to tweak the law to try to move forward yet another 2/3 urgency measure. But just as importantly, our hope is that we'll be referring to our president as President Joe Biden and our vice president as Vice President Kamala Harris. And if the team gets sworn in the third week of January, hopefully it leaves enough time for Congress and the new president to consider federal stimulus dollars, particularly around rental assistance and hopefully struggling landlord assistance, to address this. So that's the theory. The politics obviously will play out as they play out. And we need to make sure, I'll just be partisan for a moment and say, it goes without saying, we've got to win the election in 33 or 32 days to get this done. Let me just end with two final thoughts, which is, regardless of what happens with the election, I believe there will be an awful lot of tenants in the state who will be in dire need of legal advice and legal counsel. And so I've been starting a conversation in the last couple of weeks about how, with these laws in the books, these laws are complicated. I have on, I know somewhere on the Zoom, I think is my staffer, Sandra, Sandra Nakagawa, who is an Asian American sister. She is the person who actually wrote the bill. It's complicated. It took a lot of attorneys and policymakers and good policy advocates a lot of time trying to put this together, but figuring out how it gets interpreted and how it protects tenants is frankly the work of those of us in our profession as lawyers. So that's why it's important for you guys to be part of this. And I hope you're getting some good MCLE credits, but I also hope that you will be taking the step to help to defend our brothers and sisters, our family members, our neighbors, our fellow citizens, our fellow non-citizens from evictions in this area. I tried during the negotiations to push the idea that anyone who's getting evicted during this pandemic and during this recession should be represented by counsel. And a number of years ago, when I was the head of the Board of Supervisors in San Francisco, I pushed forth this idea embodied in a San Francisco ordinance that our city become the first city to require this right to an attorney if you're being denied a very significant right. And clearly, I think if you're about to be evicted from your home of decades, I think you should have an attorney. It has always boggled my mind that if I were to shoplift toothpaste from Walgreens, I will get the best attorney that a public defender's office can provide me. But if I'm about to be kicked out of my home, if I'm about to lose a kid in a child custody proceeding, if I'm a battered survivor and want to get a restraining order, or if I'm about to be deported from this country, I don't have a right to an attorney. And the fact of the matter is, and we all know this, 90% of all Americans really don't have access to legal representation because of the cost. 10% of all lawyers serve that 90% of all Americans, and 90% of all lawyers serve the top 10% of all Americans. And that's something that is incredibly problematic. But in this context, when you're about to be denied your home and you're about to be evicted, I believe that you should be represented. I tried to get that as a requirement in the bill. That was summarily rejected at the negotiation table. But that being said, two things. One, we need to bolster the public interest sector, the nonprofit sector, the legal services world, both with support and funding and pro bono assistance, as well as hopefully encouraging the next generation of lawyers and law students to think about this as an area to do practice. So whether you do this for a living 24/7, or whether you are working at a firm and this is part of your pro bono practice, I really just appreciate your interest and hope that you will be part of an army of folks that will work on this. The last thing I'm going to say, and I'll just make this a little more personal, I am the former president of the Asian American Bar Association. I got my start in part in community leadership through the Asian legal world. And when I went to law school, I took it upon myself, as I know all of you on this call do, when you're the first in your family, the first in your community to get that degree as a Juris Doctor, we have a responsibility. And I got to know FBANC leaders over the years. We all worked with each other in the community, representing pro bono cases, working to advocate for our communities in all sorts of different ways. You are part of a very honored and fortunate elite. We know that, those of us who are lawyers. And I do hope that amongst you, you guys will consider getting more involved, not just doing pro bono work, but think about running for office, think about representing. Rob Bont and I are old, longtime personal friends. I think it's fair to say he's one of my closest friends in the legislature and vice versa. When I was running for the legislature, Rob was in the class ahead of me. He busted his butt to help elect me. And now I chair the API Legislative Caucus. I'm working really hard to try to elect the next generation of API leaders around the state, particularly into the legislature. Rob was the first Filipino elected. Todd Gloria was he likes to say the second half of one because he's Hapa, but he's the second. But our goal, Rob and Todd and I, we may be the first of who we are. I'm the first API representing Eastern San Francisco in the state assembly, but we certainly sure as hell are not going to be the last. And my hope is one of the 26 of you who are listening might think about taking me up on just getting more involved in civic activities, political activities. And hopefully someday when Rob and I are termed out, it'll be one of you guys sitting where I'm sitting saying, hey, I just authored this law that protects a lot of folks. Now I need you to help defend people using those rights. So thank you. happy to answer any questions.
I don't see the questions in the box. I do have one question. I see that your career is full of public service as a prosecutor, as a civil rights attorney. And what type of skills do you think or qualities are needed for someone to be an effective legislator?
It's a hard question. I mean, being a legislator involves juggling a lot of things, right? From a substantive standpoint, you need to understand policy and have an interest and a passion for changing the world and making it better. You obviously, it's a political job. So it requires getting a lot of folks to support you, working in coalition with people, being able to figure out how to hammer out consensus on very difficult topics like how do we prevent 5 million tenants from not being evicted while not making life impossible for struggling landlords. I will say that the first thing I always tell the folks if they're interested in the type of career that I have is, do you have a passion to serve, right? It's less about the glamour of the job, and it's more about what do you want to do in life? How do you want to help people? There are a million ways to help folks. I have a lot of friends who are big firm, partners, and they're helping folks from their vantage point, or who are working as GCs in companies or otherwise working in the private sector. And I have a lot of friends who are public interest attorneys who are doing amazing work. My wife and I often joke, she's an API lawyer, runs a nonprofit service agency. And we joke that we met at an Asian American bar event and got to know each other in part because we cared about service. And that's what it's about. And so I would say, there are a million steps to get to where Bonta and I are, but it starts with sort of this passion to get involved in community and helping. And so I would say, if you care about tenants being evicted during a housing crisis and a pandemic, if you care about undocumented immigrants, if you care about the climate, if you care about discrimination and hate crimes, there's a way for you to get involved. And if you get involved, people will see that and want to work with you and want to support you. And you'll see the next opportunity to make a difference. And then all of a sudden, like Rob and I, someone's asking you to run for local office, the city council in Alameda, the board of supervisors in San Francisco. And then at some point after that, someone says, hey, Chu, hey, Bonta, why don't you think about being the first of your kind to represent your community in the state legislature? So you don't have to have a linear path on this stuff. It's just a matter of getting involved and figuring out what you're passionate about and doing it.
I have another question, Assemblyman, from a participant that says, does AB 3088 leave room for local jurisdictions to expand any local protections on top of the state? And I read that it says the Tenant Act would preempt an ordinance, resolution, et cetera, adopted by a city, et cetera, but it does not say shall.
Right. It's funny. I'm trying to look at the speaker view to just see faces on this call. Most of you guys are probably billing while listening to this. But I wish I could see my staffer's face, Sandra, because this topic of preemption was just utter legal brain damage. You could probably spend a 1 hour, you could probably spend a month in a course on procedure and preemption and state versus local preemption to sort of go through it. So the high level is the tenant advocates wanted this state law to be a floor, not a ceiling, and did not want any preemption of any ability of a local jurisdiction to do whatever they wanted. As you can imagine, the landlord community wanted the opposite. They wanted this law to occupy the field and to not allow any local jurisdiction to continue to do anything else. We came up in, I think, 2.5 pages of the bill in very excruciating language that's pretty convoluted and hard to understand unless you read it 4 times, to a compromise. And what the compromise said was any existing local law in place in this area would be allowed to stand. So in other words, we were not striking down any local provisions. But for the 5-month period between when this bill was enacted and the end of January, this state law said no new local laws that impact protections around non-payment of rent. But there was one other general principle, which is that we did not prevent a local jurisdiction from enacting eviction protections outside of the area of non-payment of rent. So basically what it says is in the area of tenant protections, when it comes to non-payment of rent, local existing laws that were enacted before August the 19th of this year remain in effect. Anything between August 19th, which was the date that the deal got struck, till the end of January, no new local laws around non-payment, but anything outside of non-payment can be legislated. So that's the gist of it. If you read the last couple pages of the law, you'll see that embodied in many, many words that were dickered over through many, many late nights. The deal almost fell apart over preemption issues. You asked the question, so that's the bloody answer.
Thank you so much for your time and your insight. Appreciate it. Hope you have a wonderful day.
Thank you. You know, one last thing I'll just say is in my younger days, I just turned 50, but when I was in my 20s and 30s, I went to an awful lot of Asian bar events and went to, in particular, a lot of FBANC parties and your annual dinners. It's been a little while, and I realized just looking at the participant names, I don't know any of you guys. I used to know your entire FBANC board. I used to party with your board, spent a lot of time with you guys. I hope when we're all back out of COVID to have a chance to go visit with FBANC, because you guys do represent the next generational leadership. And it's important for me and Rob and others to support you in that. So just know that, reach out to me, let me know how I can be helpful. And it's good to see everyone.
Thank you.
Be well. Thanks, Joey. Cheers.
Our next speaker is a colleague of mine from API Legal Outreach, who is active in the community. He is also a 1.5 immigrant, grew up in San Francisco, went to San Francisco State University, and obtained his Juris Doctorate from Golden Gate Law School, where he was the speaker of his class. He practices in housing, and also it is my honor to introduce Marco Sampson to discuss how to obtain protections under federal, state, and local laws.
Thanks, everybody. Thanks, Joey. I'm kind of humbled to share the stage with all these great civic leaders. Just want to get that off my chest real quick. But thank you for having me. So I'm here today to talk about how tenants can be protected under the federal, state, and local rules. Like David Chu said, a lot of how the laws interact kind of get complicated with the preemption issues, and I have a little bit of advice about that at the end. But I want to talk about basically the nuts and bolts of the federal, state, and San Francisco as an example for the local rules of what tenants should be aware of. What do you need to do as a tenant? All the you're hearing about all these protections and all these things that could help you if you can't pay rent during COVID. So what do you have to do? So under the federal rules, the CDC, the Centers for Disease Control, passed an order under their authority under the Public Health Services Act, Section 361. What you need to know about this is that from the time that it was enacted in September to the end of this year, the federal government is trying to protect tenants from the effects of COVID by protecting them from being evicted and exposing them to all the pandemic that's out there. So kind of promoting the shelter in place orders all over the country. So you can't promote the shelter in place all over the country if people are getting evicted. If people don't have homes, they don't have a place to shelter in. So this order was set in place to protect people in the angle of health, protecting people's health, particularly for the COVID-19. So the protection, it gives you protection if you sign a declaration under penalty of perjury to telling your landlord a bunch of things. There's a list of things in the statute, in the order that you have to tell your landlord. And if you could not pay your rent between September to anytime between September and to the end of this year, December 31, 2020, you have to give your landlord this declaration that says that, hey, I've tried to get help. I tried to find resources to help me pay for rent. I looked into the government agencies and everything like that. I make less than 99% if I'm an individual. I make less than 198,000.
Is it all right, Marco, to just kind of read this declaration real quick?
I'm sorry.
Is it possible to read from this declaration that's found on the CDC website?
So this is these bullet points that I have on the slide, these are basically what is outlined in the declaration. So in the declaration, it's saying that you need to have sought help to get rent, and then the second is that
government agencies, correct?
yeah, and that you have and that you're eligible, like you're income eligible. So that, for example, you as an individual, you can't make more than $99,000, and as a couple, you can't make more than $198,000, and then also that you are willing to pay when you can, basically. And then the last part of the declaration says that if you are evicted, you will be homeless. So the CDC is very interested in trying to prevent homelessness, especially during this this time of COVID. So all of those things, if you are named on a lease agreement, or if you have a verbal lease agreement with your landlord, every single person that is that has a claim to tenancy has to fill out these declarations, has to make one of these declarations and give it to the landlord so that they can at least have eviction protection until the end of the year. Okay, so that's what's going on the federal level, right? Okay, so that's
the expiration is December 31st, 2020.
Yeah, so the expiration for that, so you have protections until the end of the year. Note that this is only protections for payment of rent, like non-payment type evictions. You could still be evicted for other just causes, like for example, the AB 1482 just causes, or your local jurisdiction just causes, like nuisance or breach of lease or illegal activities or something like that. And also, this, just because you can't be evicted, some of our legislative leaders have already mentioned that the landlord could still go after you in civil court for the money that is owed. So just because you cannot be evicted during that time, they could still go after you for the money that is owed.
So rent is not forgiven.
Yeah, under the federal rule, but under the state rule, you can not be evicted. It's a little bit different. So the response of the state is the AB 3088, which is now known as COVID-19 Tenant Relief Act of 2020. So this says that the landlord can't evict you unless the landlord follows strict procedures. The rule expands the 3-day notice, pay or quit, to 15 days. So now that you have 15 days to pay or quit, along with that, the landlord is required to give you a declaration that is unsigned, and also information about that declaration, saying that, hey, if you sign this declaration and you fill it out and you say that you have a hardship connected to COVID, that's why you can't pay during these periods, that you cannot be evicted for that non-payment of rent. Again, you can't be evicted, but they could still go after you in civil court. However, there's 2 periods that are very important that you need to know as a tenant. So there's a first period called the protected period, which is in March 2020 to August 2020. So if your rent was due between that time, what you need to do is, if the landlord serves you with this eviction notice, this 15-day notice with the declaration, what you need to do is fill out that declaration and make sure that you say that you have a hardship due to COVID, and you have to return it to the landlord within 15 days. So if you return it to the landlord within 15 days of that first period, that means that you cannot be evicted ever. So
for that protected time period.
Yeah, for that. So rents. So if you're being evicted for rent that is due for that time period, which is the protected period between March and August 2020, and you provide this declaration to your landlord, you cannot be evicted ever. However, the landlord can go after you for the rent money in civil court. So there's a second period that I was talking about, remember? So there's the transitional period. So the transitional period is the time between September and January 2021. So this transitional period says that if you are unable to pay rent because of hardships due to COVID, then you have to file this declaration. You have to you have to deliver this declaration to your landlord, but that's not it. That's not enough. There's an additional requirement. The additional requirement is that you have to pay at least 25%, right? As the people have been mentioning, before January 31, 2021. If you do all of that, if you do, let's remember the declaration and then the at least the 25% of the rents owed, you cannot be evicted ever for that period of time, for rents owed during that period of time. However, again, the landlord can go after you in civil court for the monies owed. Okay, so that, well, that doesn't wrap it. There's a couple more things for the state side. So the state side, it's only for non-payment evictions connected to hardships during COVID. It does not protect you against other kinds of evictions, like under AB 1482 or your local outright and ordinances, just causes like again, like a breach of lease or illegal activities, things like that. So, okay, now we're down to the local level. I work from San Francisco, so I'm most familiar with the San Francisco mayor's moratorium. The mayor's moratorium was signed in March 2020, and it's effective. I think today's the last day, actually. So at first, there was a requirement of a notice to your landlord that you need to give notice that you can't pay rent due to COVID or hardships due to COVID, and then also documentation. But then the order kind of eased off on that requirement later on in the later iterations of the order, and said that it was suggested. You don't have to, but it's a good idea to provide documentations. So if you could not pay rent in a period between March and September 30, which is today, you cannot be evicted until 6 months after today, which it will be sometime in March of 2021. So eviction proceedings could start, landlords could start doing eviction proceedings at that time in San Francisco. So lastly, I kind of wanted to make all of these things make sense all together as a body. So if you step back, you kind of have the federal, the state, the city, and like David Chu said, there's all these issues about preemption. You could probably study this for a week, and you'd still probably have questions. So I've been asking.
Preemption means which law is trumps the other, right?
Yeah. So preemption, for those that don't know, is basically the idea that one law could invalidate another law. Particularly a law that is of a higher jurisdiction. For example, a state law can invalidate a local law if that local law is in conflict with the state law. So there's a lot of attorneys that I've talked to that have said that and there are preemption issues between the state and the local. There's preemption issues between the federal and the state. So it could get a little bit confusing. So it kind of depends on the attorney who you talk to, what their legal opinion is. But at the end of the day, my advice, what I tell my clients, is that you should try to satisfy as many of the laws as you can. If you could satisfy the federal rule, if you could satisfy the state rule, if you could satisfy your local rule, do it. Because if one of those or some of those get preempted, at least you have a backup plan. You have a fallback of sorts. So that's kind of just my bit. If I missed anything, please ask away. I know I kind of ran through that, but
We
yeah,
have one question.
sure.
I mean, we could also open this up with the other attorneys later if whoever the anonymous attendee is. But it's up to you, Marco. Do you prefer to answer this question?
Sure, I could try. And if anybody in the panel has another answer, you could also chime in.
Okay. It's been repeatedly said that AB 3088 is not perfect. What other policies or laws are being created or worked on currently that can provide stronger protections, and how can community members support them?
So I would just like to echo what Bonta has said in the beginning. You know, in order to kind of galvanize this, more rights for tenants and kind of protect them from these kinds of evictions, especially during these trying times, we need to get involved. We need to go out there and talk to our civic leaders. We need to talk to our legislative bodies, and just let them know that we need these things. As far as more things that are in the works, like Bonta said, he hopes that in the future there will be more protections for tenants, but this is the best that they can do right now. And other than that, the existing stuff that's the stuff that could be in the future, right? So the existing stuff is you have the CDC Act, you have the State Act, and you have your individual local rules that you have to look at. And for your particular situation, you really, really need to talk to an attorney to kind of figure out for your specific situation what rules apply.
Okay, thank you, Marco.
Thank you.
And for the next speaker, I am introducing, he is also a graduate of Golden Gate University, and he has a private practice based in Richmond. He practices, however, in San Francisco, Contra Costa, Solano. He practices in real estate, employment law, and landlord-tenant law. I am honored to welcome Andrew V. Gabriel.
Thank you, Joey, and thank you, FBANC, API, and the Asian Law Alliance for giving me an opportunity to join and sort of give a little bit of feedback as to what tenants can expect over the coming months. AB 3088 is an incredible legislative device. It provides protections to tenants, but there are a lot of pieces to it. There's no doubt about it, and tenants should be well aware of sort of what to expect in the coming months. So I want to talk about AB 3088 in particular, because there's a lot of notices and requirements there. The first one that's going to be brought up is the 15-day notices. All the notices are going to be 15 days. It is important, and I implore all tenants to do this, is count out the days and put it on your calendar of when you have to respond to these notices. It's 15 court days, so it excludes weekends and holidays. And it basically outlines how much and what you're owed. There's two kinds of notices. There's one for the protected time period, as Marco had explained. There's two periods here. Protected time period is from March 1, 2020 to August 31, 2020. There's a 15-day notice specific to that. And there will be attached a declaration that says that it's blank, it's unsigned, and I encourage tenants to carefully review it and make sure that you are qualified for the protections and that you are signing that declaration truthfully. The second 15-day notice, it is in regard to the transition time period. That's from September 1, 2020 all the way through to January 31, 2021. Now this one is going to be a little bit protected time period. The protected time period notice is going to be it's one notice for all months. Transition time period notices are a little bit different. If your landlord wanted to, he, she, or they can put new 15-day notices for every month, one for September, one for October, one for November, one for December, or one for January. And included there are declarations on each and every one of those. So be sure that you qualify for the protections for the dates that the notice outlines. And I encourage tenants to speak to an attorney or someone with a sort of expertise in this to make sure that you qualify for the protections, because there's a lot. The good thing about these protections is that they provide very broad categories, and you should speak to a legal expert to help you see which avenue you best fit in, so you can make sure you get those protections and make sure you respond timely. Now, the one that's going to be a little bit tricky for those of us who've been financially impacted by COVID-19 is the 25% requirement. There's been a lot of talk of how much is 25% of what, et cetera, et cetera. The short answer is the transition time period. Rents that have been unpaid from September 1 to January 31, 2021. Tenants need to pay at least 25% of that amount owed in order to be afforded the protections of to prevent an unlawful detainer being filed against them for the transition time period. So the tenants now, I encourage you to start planning and saving. If you can't save for the full month's rent, at least minimum try to plan out 25% to give to the landlord. And that way you can at least be protected from going through an unlawful detainer, which nowadays it's an expedited proceeding that's faster than going through small claims court, and it has a heavier impact on you than if you were to have a judgment against you in small claims, because you would essentially be removed from the property versus having a debt looming over you. It's kind of pick your battles, and I think that's something to consider. Now, let's say you pay the 25% for the transition period. Your debts are no longer subjecting you to an unlawful detainer. That doesn't completely mean that it doesn't mean it's forgiven, by no means. So still plan out how to work how to save, how to come up with a payment plan, because traditionally small claims court had jurisdictional limits. Individuals were limited to $10,000, and for corporations and LLCs and other entities, it's $5,000. For COVID-related debts, the jurisdictional limits do not apply. So if your rent is $3,000 a month and you have about approximately $14,000 in unpaid rent, you can still be found liable for the $14,000 debt. It just means that you won't be evicted based on owing that debt. So keep that in mind. And I think one thing we should discuss later on is so what we can do to help if small claims court actions suddenly start flooding the community. But for now, I'll just leave it at that, the debt does not extinguish. It just means they cannot evict you based on that. And know that, and this has been said throughout here, I think Assembly Member Chu had explained this, that AB 3088 only applies to non-pay. There are a lot of other ways that landlords are exploring in order to essentially evict their tenants. And with that, I encourage tenants to make sure you review your leases, review your terms, and make sure you're in compliance with them. If you have subtenants and your lease does not allow subtenants, you need to address that somehow. If you have no pets and you have pets in the property, address that immediately to make sure that you do not have any violations of the lease, because that is independent and separate and apart from AB 3088 protections. Now, there are a number of local ordinances that try to fill the gaps with AB 3088, and that's essentially addressing all the other kinds of evictions. I practice in the Contra Costa County, Solano, Alameda area, and there are local ordinances all around. Contra Costa County has enacted an ordinance that basically says that you have to provide additional notices for other kinds of evictions, and failure to include additional notices is fatal to the unlawful detainer. And that's why any notice to evict, you should definitely speak to an attorney. And when you meet with that attorney, bring everything that you have received from the landlord. Like I said, Contra Costa County has a specific form that landlords are to serve with their notices to terminate. And I believe as do my mind's slipping me right now, but there's a notice for reason of termination, notice of tenants' rights. All those forms are supposed to be included in the packet that they serve the 3-day notice. And also consider that that a landlord who blatantly violates these ordinances, they can be subject to some serious penalties, and that's why it's also worth speaking to an attorney to make sure that the landlord learns his lesson for violating these ordinances. Again, by example, Contra Costa County, if a landlord is blatantly ignoring, willful, knowing, and recklessly violating the ordinance, you can sue them and sue for double and triple damages for the stress and the pain that they put you in through these tumultuous times. And so several jurisdictions have given avenues for tenants to have protections. Now, all of these things assume that the landlord is informed. I will not ignore the reality that there are landlords who are not informed. And the approach that I have taken when I have a situation in front of me where a landlord is throwing their hands up at the law and using extrajudicial means to remove someone is to inform them of what the process is and why what they're doing is not going to work. I've taken an informational approach. I usually send a packet approximately 50 to 70 pages thick of information in regards to ordinance and such, because one, it makes sure that the landlord becomes informed and that he, she, or they know exactly how to approach the situation and why what they're doing is just not permissible right now during these times. But also it gives the tenant something in their back pocket that if the landlord continues and proceeds with this eviction, that then the landlord's, it can be argued that the landlord's violation of the ordinance was willful, knowing, and reckless, and the tenant has an ability to have recourse for the landlord's bad behavior. And so, like I said, if you receive any notice, doesn't matter if it's a 3-day notice to quit for a lease violation or a 60-day notice for an owner move-in, speak to an attorney, make sure that you bring all documentation. And if you do end up having a dispute or some sort of disagreement with your landlord, get it in writing, text message, email, fax, if you use that, just as long as you have pen to paper on there, and you should be a-okay.
And Andrew, your office is open regardless of COVID, but would it be best to call you should the participants have any questions?
Yes, absolutely. I typically do phone consultations, and I invite anyone who is having issues to give me a call, schedule an appointment, and I like to see all the documents beforehand. That way I walk into the appointment prepared. I do have to caveat that unlike these fabulous organizations, I am a private office. And so I do charge, but my initial consultation, I always offer a free 30-minute consultation. And that's how you can sneak in a free notice review or something like that. So you at least know your position and you're not going in completely unaware of your rights.
And your office has language capacity for Tagalog and Spanish speakers, correct?
That is correct, yes. I myself, while I am proud to have grown up in a Filipino household, I recognize I'm not the best understanding, but I do use sort of third parties to help provide translation services. There's a large Filipino community as well as a Spanish community around me. And I do like to make sure that I fully understand the scenarios that you're going through.
Thank you for that information. I'm
Thank you for
going
having me.
to put up the next slide now, and I think it's worth opening up this hypothetical to the panelists and even maybe make it interactive to the participants. And thank you for the participants for answering the polls that were sent out earlier in the presentation. That helps indicate, who is learning from these programs that FBANC is putting on. And we appreciate you being here. And this is the hypo. John Doe lives in Santa Clara, California, where Asian Law Alliance is located. He is a part-time student and rideshare driver to earn income. He rents an apartment with his partner. Both of their names are on the lease. The total rent is $5,000 per month, and both tenants equally split the rent. When the Santa Clara County ordered shelter in place on March 17, 2020, John stopped driving and earning income. His partner had to work from home due to COVID-19 and purchased equipment due to the shelter in place order. Once the shelter in place order was lifted, John started driving again. He purchased cleaning supplies and mask equipment to protect him in his drive. Shared ridership, however, has significantly dropped, and as a result, he has a reduction of income. They asked the landlord for an extension of rent for the months of August and September. They are unable to pay rent for the month of October. Just gonna open this up. Maybe Kenneth, since you live in Santa Clara and you have most experience, if you want to start us off.
So first of all, the August part is somewhat interesting. All that talk about preemption and which law applies, well, that kind of comes into play in August. So Santa Clara County had their own rent moratorium. As far as residential rents are concerned, that moratorium expired on August 31st. They initially extended it, but when AB 3088 came in, they ultimately decided that from August 31st on, AB 3888 would apply. But on August 1st, you still had the Santa Clara County rent moratorium. So under there, they also have a requirement that the landlord is served with a specific form that says, I declare that I've had a COVID-19 related loss of income, but their requirements were actually more stringent. They required you to count, they gave a bunch of examples, or they required you to put something else, and they required that you turn in paperwork. Now, it's my belief that this more than qualifies for the AB 3088 requirement, because it includes not just a statement saying I lost income, but all this paperwork that shows this loss of income. So for August, even though 3088 is going to apply towards repayment, they would have needed to have turned in the Santa Clara County requirements, which, again, in my opinion, those requirements satisfy the AB 3088 requirement. That's just for August. Anyone else have anything to add?
I just wanted to add something really quick. I certainly hope John took advantage of the unemployment benefits. And if he had any questions, to do participate in FBANC's many wonderful opportunities to get help with unemployment assistance. That was just my little chime in there.
That is actually a great chance for me to promote our upcoming unemployment form assistance clinic, which is going to be happening on October 19th to the 25th. So if you or you know someone who needs help filing for unemployment, please take advantage of that free resource. Again, that's on October 19th to the 25th. And more information on that can be found on FBANC's website, which is fbanc.org.
Mari, isn't it true that there was a virtual clinic from April to May that helped 528 callers?
That's right. FBANC launched a 2-month clinic with the Asian Law Caucus from April to the end of May, which Andrew was a volunteer for, and so did Joey. So thank you to both of you for volunteering for those clinics. And that's right, we did help over 500 clients with unemployment benefits, including, state disability insurance and also paid family leave. And we are relaunching that same clinic again in October for about a week, just to see what kind of demand we have again for something like that. And this time we're partnering up with Asian Law Caucus again, as well as AIDS Legal Referral Panel.
Great. Anyone else have anything to add about the hypo? How will John and his partner be able to avail protections? And this is also open to participants. If you have any answers, we welcome that as well.
I just want to chime in addition to the use of the free resources that that John could avail himself, but also one thing. So I represent both landlords and tenants, and I think the number one thing that John needs to remember is communication is key here. The landlords do not like uncertainty. This is a business to them. This is an investment, and so they more so than losing or facing losses in their business is that they want to know certainty. So, John should absolutely talk to his landlord and inform him of his circumstances, not only as, in order to invoke protections, but just in terms of maintaining that relationship and, preventing the landlord from becoming desperate, so to speak. But that's just my 2 cents for that.
Marco, do you have any thoughts?
I think they've said it all.
Right. So again, it's important, the communication, the declaration that you've read and reviewed carefully to be provided under AB 3088. He'll have to pay 25% of the rent for the transitionary period, which is about a month, and 25% of the rent due from September to January 31, 2021. And there is a question of should the tenants, John and his partner, pay in lump sum or pay incrementally throughout each month. And I think it's upon the individual person's ability to pay, but it's best to again keep the relationship between the landlord, if possible, positive and civil, and maybe perhaps do pay the 25% of whatever they can. One question that was answered earlier is what other types of policies might help tenants, and I really think the debt, the looming debt, people having to take out loans to pay for rent, is an issue that needs to be seriously considered. With a judgment, if the landlords will have to go to small claims court to enforce, or to collect on debt, and that is enforced, and if unable to pay, there will be a judgment on one's record. So does anyone else have anything to chime in?
With regards to that, I think it's also good to consider the opposite side of the coin with regards to, the landlords and their mortgages and things like that. So there's some mom and pop landlords that may also experience the pressure of not receiving income, this rental income, because of COVID-19, and if stronger protections for landlords should maybe also be coupled with stronger protections for tenants as well. And that's it.
Great, it's 4:30. Thank you so much, panelists and esteemed guests, and for the participants who have asked questions. Again, our offices are available for you to do an intake, and we thank you for your time and attention.
Thank you.
Thank you, everyone. Thank you to all of our panelists today.